We have criminal trial attorney Sara Azari and Florida State's attorney Dave Arenberg. It's good to see you, Dave. It's good to see you, Sara. So let's just go point for point quickly here. The big ticket, Sara, I have to believe, because they haven't said what the appeal is yet, but they complained plenty about the financial crimes evidence that got in. So what's the basis for the appeal there?
Well, Chris, look, the financial crimes for 2.5 weeks or 3 weeks, that's all we heard. That's all this jury heard. And then when it came time for closing arguments, Waters, the prosecutor, said, oh, we don't have to prove motive. Motive is not an element of murder, so you don't have to even worry about it. Well, it was the motive that was the guise for bringing in all of that evidence, which essentially was not only character assassination for Murdaugh, but it's what necessitated him taking the stand. So that's why this case is a little bit different than the average case where we go, well, if the defendant takes the stand, then they're essentially opening the door to bad acts and character evidence. He didn't open the door. The door was already open. So that raises a very interesting issue on appeal. I'm not saying it's winnable, but it's certainly a strong issue. And there's also the Doyle issue on his cross-examination, the violation of, hey, you didn't go back to SLED after your arrest to talk to them about the kennel lie. You didn't clear up that lie. Well, he had invoked his Fifth Amendment to remain silent. There's that issue, and then the disconnect with the rain jacket is also a big issue. So the defense has some grounds to file a viable appeal, but like you said, very low percentage of them are overturned.
Viable or winnable? Dave, what do you think?
Yeah, good to be with you, Chris. And Sara, she's an awesome criminal defense lawyer, but I disagree with her here because even if there was error here, and I agree that the prosecutors did go close to the line when they elicited testimony that seemed more like character evidence than motive evidence, but ultimately it's harmless error because as we saw from the jurors afterwards, they based their decision on Alex's lack of credibility, his lying about not being at the kennel that day, and his lying when he took the stand about why he lied. That's the reason why he was found guilty. It disgusted the jurors, it disgusted the judge, and even if there was some error, it would be seen by the appellate court as harmless error and the conviction would stand.
All right, let's bounce it the other way, though, Dave, because what she says about the Doyle case, which just for everybody at home means, look, there's a standard that once you invoke your Fifth Amendment rights, you don't have to talk to anybody anymore. You didn't have to talk to anybody to begin with. But for them on the stand in front of the jury, to make it seem like his not going to the authorities to correct what wound up being, the biggest nail in his coffin, which was the inconsistency between his story and what was on his son's Snapchat video, he didn't have to clear it up. Is that something that could be seen as prejudicial enough to have helped shape the verdict and therefore overturn?
No, I don't think so, Chris. I think, if anything, it's harmless error. Look, he took the stand in this case. And when you take the stand in your own defense, that's your own decision, and that wipes away a lot of the mistakes of the trial. Because ultimately, then, it's really about his credibility. That's why the jurors made this decision. Now, is there a Doyle issue here? I mean, perhaps I would disagree as a prosecutor, but again, I think that's small potatoes considering what really went into the jurors' decision. We saw in their interviews afterwards, it wasn't any of that other stuff. It wasn't about financial motive, which, by the way, the defense did open the door to. I'd have to disagree with Sara. It was the fact that he's a liar, a con man, a cheat, and he lied to the jurors' face. They were repulsed by him, and that's why they found him guilty.
Final point to you, Sara.
Yeah, two things. One, again, this is, with respect to the jurors, the jury, if there's any jury misconduct, there are certainly red flags to investigate. That is not necessarily an appellate issue. It's a motion for a new trial before Judge Newman. If it's denied, then that also can be appealed. But to Dave's point, again, the door was open, unfettered, unlimited amounts of character and propensity evidence came in. So I see this case a little bit differently than just the average case where the defendant testifies and essentially opens the door to character and motive or propensity.
And also, that's very helpful, though, Sara, because so they have two avenues, Dave, right? They're going to try to overturn this trial because of what an investigation may show the jury was doing that it should not have done, right, which was kind of seeded by the juror who got dismissed. And then you have the appeal of the decision. So there are two different roads to go down, and when they diverge in the wood and we figure out which way is their best, we will reconvene and rediscuss. Dave Arenberg, really good to have you on the show. Look forward to seeing you again. And Sara Azari, always a pleasure. Always. All right? Thank you to
Have a
both
good
of you.
weekend,
All right,
Chris.
let's take a break. When
And
we
Dave.
come back...